For more, let's welcome Michelle Tessier, who held numerous CSIS roles, including Deputy Director of Operations. She's now a Senior Fellow at the University of Ottawa. Michelle Tessier, thanks for joining me.
My pleasure. Thank you for the invitation.
So I want to start with what we heard from the CSIS Director, David Vigneault, today, once again at committee, once again talking about foreign interference, specifically cyber threats against MPs, but again, facing more questions about that NSICOP report from last week. What did you take away from what we heard from the Director?
Well, I think, and understandably, the role of the committee is to ask those questions in terms of what can be improved upon. And I think that's what came out, both in terms of the cyber incident and how the whole mechanism of informing parliamentarians can be improved upon, which the Director of CSIS admitted right from the outset, as well as the ongoing concerns with that came out of the NSICOP report and Bill C-70, like, is this going to be enough? Is there more we can do? Is this going to solve some of the issues that have been raised? So that is the work of the committee and others to look at all these questions.
And so flowing from that NSICOP report, there's been a lot of focus, obviously, on the allegations involving parliamentarians wittingly assisting foreign state actors. We have political parties who are pushing now to have the public inquiry take this over to look at this. So if that were to be the case, what would Justice Marie-Josée Hogue be able to do and say and tell the Canadian people that NSICOP hasn't already been able to disclose?
I think that's a very, very good question, because obviously the Commission's mandate is very focused. It's to look at the foreign interference story during the two federal elections and how the whole process can be improved upon in terms of the elections, not so much the whole other issue of foreign interference. And certainly the mandate right now isn't anything to do with laying charges or referring anything to law enforcement, not that that's necessarily what is being sought here either. So it's a good question. If anything, if it may allow for the point that you've made, is this a way that can reassure Canadians that she's looked at it, yes, is aware, and as the Commission does its work, it will identify ways forward to deal with foreign interference. I mean, it could just be, frankly, another reassurance to know that somebody else has looked at it and is able to at least say, I've looked at it, and any issues that were raised we will be looking at as well and making recommendations on. Because I don't think, in terms of the existing mandate, that it was necessarily set up for this type of thing.
And so talk to me a bit about how there's a way to potentially strike a balance here between the need for transparency. There are demands, of course, to have the names of the parliamentarians who are involved, but of course that also has to be balanced against national security considerations, protecting intelligence collection. How do you see that balance playing out in this case?
Well, I think the important thing here is it highlights the current gaps that exist between the CSIS's inability to share with all political parties, all parliamentarians. It's certainly not a lack of willingness that from the service's part. It's more the CSIS Act is very restrictive in terms of who it can share intelligence with. In an ideal world, and this is one of the things that my understanding of what Bill C-70 is proposing, is that would widen who can receive CSIS intelligence, classified intelligence, so that they can take actions. You don't need to disclose the details of classified information in order to make a decision. And if you've got loopholes that exist, if you've got MPs of concern who may be witting, may be unwitting, if there are vulnerabilities in nomination process, if there are other fundraising concerns, what have you, allowing an intelligence service to have those ongoing discussions with all political parties, I think would be the ideal solution. And I think that's what we're seeing here is the inability to do that other than going through a very laborious threat reduction mandate process, which was not set up for this. And I think that's what we're seeing in terms of the frustration of not being able to get more information and be able to act on it.
Right. We did hear Mr. Vigneault in committee today again say that, yes, political leaders can act on information they learn from classified intelligence without revealing that intelligence publicly. So to your point then, does this really become an issue for political leaders, for Parliament, for how political parties operate in terms of being able to detect and prevent foreign intelligence right on the ground?
Absolutely. And it's, as has been said, foreign actors, hostile actors, know what the loopholes are. And if they feel that there are no repercussions to their actions, if they feel that there are restrictions that will not hinder what they're trying to do, then obviously that's a risk for Canada, for Canadians, and for our national interests. And so anything that can counter that and that can shine the light on their activities, and I know Director Vigneault today mentioned the mere fact of having a discussion and more discussion is a very good thing, so that people may all of a sudden see that they themselves are victims of foreign interference or hear of somebody who's a victim of foreign interference, and now will recognize it. And I think that's what I find personally is one of the greatest successes of the NSICOP report is they really did release quite a few details and gave concrete examples. And that way people have a better sense of what we're talking about when we're talking about foreign interference.
Okay, then in the moment we have left, I want to build on that and I guess ask you a wider question about intelligence based on your experience, because we've constantly heard throughout this entire story about foreign interference over the past year and a half that intelligence is not necessarily evident. So as we read through reports like NSICOP, can you, I guess, really explain how that phrase applies, especially when it comes to what we're seeing about parliamentarians and this idea of witting foreign interference?
Absolutely. And that, to me, that point you've just raised is my greatest priority, frankly. If I were to be waving a magic wand, it is very difficult in the current judicial system of Canada, the criminal system, of protecting intelligence. It's an open court process, understandably, if you're accused of a criminal act, you want an open court process. But it's a very convoluted way to be able to protect intelligence. It has happened in the past where a criminal, during a criminal proceeding, where a superior court judge has insisted on seeing the classified intelligence, has seen it, and has nonetheless gone on and made their rulings, but it's not a norm. Normally what happens is either the service allows for the information to be disclosed because it feels that the sources are protected, or it's happened, we've seen it in terrorism cases where the sources become sources of the RCMP, as an example. But it is not an easy process. There are ongoing discussions all the time between the service, the RCMP, the Prosecution Service of Canada, all trying to see what can be used and can we protect the sources. So any system that would allow an easier use of intelligence, and that would mean an easier ability to protect some of that intelligence, but still allow a judge to see it and use it, that would be a great win, in my opinion.
All right, we have to leave it there. Michelle Tessier, really appreciate your analysis on this. Thank you so much.
You're very welcome. Thank you for taking the time.